Well, as all of your faces are appearing on the screen, let me be the first to welcome you to this afternoon's program of the EPA Academy on the state of climate litigation. Issues related to what I will refer to as this hot topic of climate change are going to dominate the field of environmental challenges for a long time into the future. And we at the Academy want to do what we can to keep the membership up to date on what's happening in this area. Before we begin, let me thank all of you out there who are members for joining the organization. And for those of you who are not, I encourage you to join. It's the best deal in town. No membership fees and dues. We do ask for an annual contribution or at any other time you might like. But please consider that we are looking to continue and expand our services as an association. And we're up just about 2,700 members, and we're over 66,000 years of environmental protection, public health protection experience. So it's quite an experienced group. This academy is one of our featured programs, and in the new year, we already are planning a session on plastics and another one on the Great Lakes, and there are more in the works. We don't have things locked down in terms of the details, but that will be coming up soon. During the course of today's session, if you have any questions, please put them in the chat. And between Chuck Elkins and Allison DeVicki and me, we'll try to keep up with them. I can't guarantee we'll get to all of them. So on to our program today, dealing with climate change is playing out globally, nationally, regionally, and locally, and in many different venues. International organizations, national, state, and local legislative bodies, NGO groups, and the private sector as well. Today, our focus is on the courts and what is playing out there. And we have three absolutely outstanding experts to bring us up to date on the latest in climate litigation. Our panel includes Michael Berger. He is the executive director of the Sabin Center for Climate Change Law at Columbia University. Michael Gerrard, the founder and faculty director of the Sabin Center for Climate Change Law at Columbia. And finally, and not the least, maybe the last of the three, Patrick Parenteau, who's professor of law emeritus and senior fellow for climate policy, Vermont Law and Graduate School. And Patrick and I first met on a long walk along the beach in South Carolina talking about grouse hunting back in the 1980s sometimes. So, Pat, if you would get us started by telling us a little bit more about how you got into this field of climate litigation, and to the extent possible, and not in any great detail, a sense of the magnitude of what's going on globally, nationally, regionally, whatever, in terms of climate litigation. Pat, take it away.
Thanks a lot, David. And hello, fellow alums of EPA, the great institution of EPA. And let me put in a plug right now for all of us to rally support for the people in the agency who are under tremendous pressure, as you all know, with threats and against their civil service status and so forth. So I think we all need to make a special effort to reach out to them and give them the kind of support they deserve. So I first got involved with climate back in 1978 in the Carter administration when I was with National Wildlife Federation. And we were having a meeting of what we called the Group of 10. And into the room burst Rafe Pomerantz from the Friends of the Earth. And he said, "It's the climate." And so we were focused on climate change a bit, even that in that era. And of course, the CEQ chair was my dear friend Gus Beth. And he was the one who under Jimmy Carter, who first wrote a very, very detailed analysis of what we knew at that time about the emerging threats of climate change. So I've been at it for a while. I've taught it. I've written about it. I've participated in some of the litigation. I've tried to inspire some of our young, aspiring environmental attorneys to focus on it and devote themselves to it because they're going to be living with it for their entire career. So that's a quick, entree about how I got involved in this. I'll turn now to just really a real quick sketch because we got two other experts here who, trust me, they are the real deal when it comes to tracking and following climate litigation and all things climate policy, state, federal, international. But anyway, the Sabin Center, which Michael Berger and Michael Gerrard co-direct, or at least are both leaders on, it maintains the database that tracks all of the cases, and I mean literally all of the cases globally, day by day. They keep this database really up to the minute in terms of what's happening in these cases. You can get access to the pleadings and the decisions and the arguments. They do a running commentary and analysis. So that's your go-to source if you want to know what's really going on with climate change. There's over 2,500 cases across the globe, and they span every field of law that you can think of: constitutional law, international law, comparative law, domestic law, tort law, regulatory law, both cases that are seeking to increase the level of action to transition from fossil fuels to greener sources of energy and transportation and so forth, but also cases, and more of which we're going to be seeing, right, that are challenging governmental efforts to regulate emissions and sources of fossil fuels and shift dramatically away from reliance on coal and oil and gas and so forth. So it's a huge area of law, global, international law, domestic law, raising all kinds of path-breaking scientific questions. Climate science, of course, is becoming more and more robust, but there's still many areas that are under active research and demonstration. So in terms of environmental litigation, and I started my career with in 1974 with the National Wildlife Federation litigating these early cases. I mean, this is the new frontier for sure of law, and in terms of no matter where you are in the practice of law or in terms of environmental and climate policy, this is both the most terrifying moment in my history, but also the most exciting in terms of the opportunities to really make a difference. So maybe I better stop with that, and we can get further into the individual areas that we're going to talk about.
Well, thanks very much, Pat. And you heard it here first that this is kind of the really most exciting area, and you have a chance to be in, not necessarily on the ground floor, but with some of the best experts around. Our good friend Stan Myberg, who I see there, has pointed out that there happens to be a Sabin Center down at Wake Forest as well, not related to Columbia, but I'm sure a wonderfully outstanding entity as well. So Stan, thank you for pointing that out. Okay, moving right along, Michael Berger is now going to tell us a little bit about himself and how he got into the field of climate litigation. Mike, take it away.
Sure. Well, first, let me also echo it's a pleasure to be here. Very honored and happy to have the opportunity to speak to this group. My first job out of law school was with the Office of the Corporation Counsel of the City of New York, working on environmental and land use law issues during the Bloomberg administration. Some of the things I was able to work on during that time included Massachusetts versus EPA, Connecticut versus American Electric Power, and the city's standing up the Regional Greenhouse Gas Initiative, and the initial efforts to do long-term planning around adaptation for our water supply. So I was involved in some of the very earliest, biggest climate cases. When I made the move into academia, I continued to focus on climate litigation as an area of study, both on the doctrinal end, looking at some of the big administrative law questions around it, as well as the role of stories, narratives, tropes in the constitution of environmental and climate change litigation. When I came here to the Sabin Center to join Mike 10 years ago, climate change really became the center and sort of the totality of my efforts and my work. And over that time, I've spent a lot of time working with the members of the Sabin Center who actually maintain those two databases, which I put into the chat so you can access it, the global litigation database and the US litigation database, but also assessing the state of climate litigation, looking closely at the range of cases that are taking place and so forth and so on. So a lot of collaboration with Mike and others on our team around big picture, thinking about climate litigation, as well as definitely deep down in the weeds analysis of what's going on in those cases. The last thing I'll just say quickly is that in addition to my role at the Sabin Center, I'm also of counsel at the law firm Scher Edling LLP, which is counsel to many of the plaintiff states, cities, and counties that are suing fossil fuel companies. And we'll be talking about those cases, and Pat will be talking about them in detail a little bit later on.
Very good, Mike B. Thank you very much. Moving right along to Michael Gerrard, Mike G. And we owe you a special thanks for enduring the trials and tribulations of Amtrak to be here. So thank you very much for the extra efforts to get here. And again, tell us a little bit about yourself and how you got into this field of climate litigation.
Thanks very much, David. It's a pleasure to be with you and to be in front of this distinguished group. Let me first say that the Sabin Center at Columbia and the Sabin Center at Wake Forest share a name because we share a donor. Andy Sabin, very generous fellow, is the major donor for both groups. So I entered law school in 1975 to become an environmental lawyer, having grown up in a very contaminated town, Charleston, West Virginia, amidst a lot of air and water pollution. And when I graduated in 1978, I joined an environmental boutique and became an environmental litigator. Called Burley Cass and Case. It's not around anymore. When it broke up in '94, I moved laterally to the New York office of a big firm, Arnold and Porter, and was a partner there for 15 years. But during that time, I wrote some books, and in 2007, the ABA published the first edition of my book, Global Climate Change in U.S. Law. That increased my knowledge of, interest in, and alarm about climate change. And in January 2009, the same month that Barack Obama was inaugurated, a whole different spirit about the land, I joined the faculty of Columbia Law School to teach environmental law and energy law and climate change law, and I founded the Sabin Center for Climate Change Law. And a few years later, we were able to bring in Mike Berger, who has done a wonderful job helping to expand. So we now have 16 full-time lawyers at the Sabin Center, working on a whole variety of legal matters on climate change at the international, the national, state, and local levels.
Excellent. Well, we have, again, three of the most outstanding national experts on this. And Mike, when you said you were from Charleston, West Virginia, our regional counsel in Chicago, Gail Ginsberg, always used to say she was from Charleston, West by God, Virginia. And
exactly.
Remember that well. So even though it's extremely contaminated, I grew up on a contaminated river as well. It birthed some wonderful environmental lawyers. Well, now we're going to start getting into a little more specific detail, and I'm going to ask Mike B. to lead us off to tell us a little bit about some of the challenges around greenhouse gas rules that we have, and a little bit about to enforce or not to enforce and what might be happening with those rules. Mike, let us in on your knowledge about this.
Sure thing. And I'll try to be brief and to not get too deep into the weeds. So I'm going to take a relatively high-level look at some of the ongoing climate cases around the Biden administration's efforts to use existing authorities under the Clean Air Act to regulate, and under the Clean Air Act to regulate greenhouse gas emissions. As people know, there is no separate legislation providing for distinct authority to regulate climate change, and in the until the Inflation Reduction Act provided a great deal of funding, incentives, and otherwise to address the crisis. And so for since the Obama administration, there have been efforts to at first use the Clean Air Act to regulate, and then afterwards to walk away from those regulations, or at least decrease their stringency, and then over the last few years to re-up on them. So I'm just going to flag a few key cases that are underway, challenging some of the signature initiatives of the Biden administration. First, in the DC Circuit, we have West Virginia versus EPA. That was back in May. A number of states challenged the final rule that EPA had promulgated that did two things. First, and this is in regards to power plants. The first is that it repealed the Trump administration's Affordable Clean Energy Rule. And then it set standards for greenhouse gas emissions for both new and existing fossil fuel-fired electric generating units, meaning both gas-fired and coal-fired power plants. This is one of several uses of Section 111 of the Clean Air Act that the agency has used in order to get at greenhouse gas emissions. The petition for review contends that the final rule exceeds EPA's statutory authority and is otherwise arbitrary and capricious. And one of the main arguments, and this is something that this case was actually argued in the DC Circuit last week on Friday, one of the main arguments that was presented in the briefs and that the judges were clearly interested in is whether carbon capture and sequestration is a viable technology that has in fact been adequately demonstrated at the rate of capture that EPA relied on. EPA, in establishing its rule, relied on the idea of a 90% capture rate from CCS technology at power plants. That formed the basis for the standard, and there was a great deal of exchange on whether or not the existing evidence fully supports that rule. The case was argued on Friday. I'm going to talk about sort of all of the cases at once, because as the administration changes in January, we're going to see some interesting, developments in all of these cases. Okay, so the second rule I wanted to flag is that's being challenged in the case Kentucky versus EPA. And back in April, Kentucky and 24 other states filed a petition in the DC Circuit seeking to vacate the EPA's final rule on light and medium duty vehicle emission standards for model years 2027 to 2032. The petitioners again asserted that the final rule exceeds EPA's statutory authority and is otherwise arbitrary and capricious. And that case is currently being, briefing has been, well, not fully completed. The reply briefs are yet to come. But in this action, EPA set emissions standards for new vehicles under Section 202A. In setting these standards, the EPA also set criteria pollutant standards as well as greenhouse gas emission standards. These build on EPA's previous standards issued in 2021 for the 2023 to 2026 model years. EPA relied on a number of rationales in setting these new standards, including the negative health outcomes associated with existing levels of pollution, the contribution of greenhouse gas emissions from motor vehicles to the worsening effects of climate change, and recent technological developments with zero emission vehicles, and elsewhere that indicate that more stringent emissions standards across vehicle fleets are feasible at a reasonable cost and would lead to significant improvements in public health and welfare. The challengers to this case are basically arguing, they're arguing many things. There are many, many arguments in each of these cases. I'd say that one of the key arguments in this case is that there are challenges to various technical elements as being arbitrary and capricious. There are also challenges to, similar to the earlier EPA question, West Virginia versus EPA case, which involved the major questions doctrine as to whether or not EPA is really acting as kind of a, vehicle regulator and choosing electric vehicles over gas and oil-powered vehicles. Nebraska versus EPA. This case was also filed in May 2024. And in this case, the Nebraska AG led a similar coalition or the same coalition to file a petition review also in the DC Circuit seeking to declare EPA's final rule for greenhouse gas emissions standards for heavy-duty vehicles, phase 3, as unlawful and to vacate the EPA's action in that case. That case has not yet progressed as far. It has not been fully briefed. That process is currently underway. Similar to the earlier case, Kentucky versus EPA, the case would have significant impacts on the heavy-duty vehicle standards and emissions reductions overall in the transportation sector. Similar but different, there is West Virginia versus the National Highway and Traffic Safety Administration, which is a case in which West Virginia leads a coalition of states challenging NHTSA's final rule on new fuel efficiency standards, fuel economy standards rather, for passenger vehicles. These standards, these cases were actually filed in multiple federal circuits simultaneously, and they were transferred and consolidated in the 6th Circuit through a lottery where West Virginia had filed its petition for review. And here again, the contention is that the CAFE standards for heavy-duty pickup trucks and vans and for passenger cars and light trucks for various different years all exceed NHTSA's statutory authority and are otherwise arbitrary and capricious. So all of those cases are pending in the courts of appeals. They're at various stages. None has been decided. One has been argued. One has been briefed, basically. The other has not been briefed. And all of them await the Trump administration's announcement that it intends to reconsider these rules. And we will see various motions to stay or hold in abeyance the litigation while the incoming administration reconsiders its position on the rules. It'll be interesting to see whether anybody opposes those motions to hold those cases in abeyance, but almost certainly that is what will happen, as in they will be held in abeyance. And so we have big ticket litigation pending over big ticket rules, all of which is about to go into hold mode while the Trump administration announces its intent to reconsider the Biden administration's climate policies across the board. One other case I just want to flag before turning it over to the next speaker is that there is a case in the U.S. Supreme Court where there is a cert petition pending, and this is over the California waiver. Ohio and 16 other states have filed a petition for writ, arguing in essence that the provision of the Clean Air Act that grants California special status and EPA the authority to give it a waiver to set its own more stringent emission standards is unconstitutional and violates the equal sovereignty doctrine. We don't know whether there will be a determination on that petition prior to the change in administration, but it would be reasonable to expect that the court might await the incoming Trump administration, which previously revoked California's waivers, and to see whether the incoming administration will decide to do that again. I think I stayed within 10 minutes. I will stop there, Dave, and turn it back over to you.
Very good, Mike. Lots of action there. I'll just ask Pat first, and then Mike G, if you've got any reactions, comments to what Michael has had to say about the greenhouse gas regulations.
I would just add one more rule that's being challenged, and that's the methane rule regulating methane emissions from oil and gas operations, and also the methane fee. So the way that's set up is EPA, under the Inflation Reduction Act, was given an option of setting standards to reduce emissions, including flaring of gas from oil and gas operations, or imposing a fee for those who weren't going to comply with the standards. So both of those aspects of EPA's methane rule are being challenged. The good news there is the DC Circuit denied a motion to stay the rule. So the rule is in effect at this point, even though it's being challenged. And of course, as Michael Berger has also already said, we're not sure what the Trump administration is going to do with it, but we can be pretty sure it's not going to be fully supportive of it. With that, I'm going to turn it over to Michael Gerrard and let him weigh in, because he's written a really important analysis of what's going to happen with these challenges when there's a change in administration. So Michael, take it away.
Thanks. First, let me mention a couple of other cases that don't directly involve EPA, but I think are of interest. The Securities and Exchange Commission issued a very detailed regulation on disclosure of greenhouse gases by publicly listed companies, and also their financial vulnerability to climate regulation, to the physical impacts of climate change, and so forth. These rules were challenged in a bunch of different cases around the country. They've been consolidated before the Eighth Circuit. The SEC has stayed implementation of the rule, and it's almost certain that the Trump administration will revoke it. Meanwhile, California adopted a couple of important laws that actually in some ways go further than the SEC rule. Those are also being challenged in court, but they're still in effect. A couple of important and interesting cases under NEPA, and this is an audience for which I do not need to spell out acronyms like this. So a couple of weeks ago, the DC Circuit, to everybody's surprise, issued by a 2-to-1 vote, a ruling that CEQ did not have the authority to issue regulations under NEPA. They've had those regulations in effect since 1978. Everybody assumed they were valid, but the DC Circuit took it upon itself to decide an issue that hadn't been raised or briefed by the parties, and said that CEQ did not have the authority to issue binding NEPA regulations. CEQ, the administration has sought en banc review before the DC Circuit, meaning they want all the active judges to review it. So we'll see what happens with that. Yesterday, the Supreme Court heard argument in a case called 7 Counties Infrastructure Coalition versus Eagle County. And that arose because the Surface Transportation Board had approved an 80-mile rail line in Utah that would carry oil. A full environmental impact statement was prepared. The DC Circuit struck down the EIS because it found that there had not been adequate consideration of some of the indirect impacts of the rail line. So the Supreme Court heard argument on that yesterday, and it seemed pretty clear that they were going to overturn the Surface Transportation Board's decision annulling the approval of the project. But it's not clear exactly how narrowly or broadly they will do that. When the Supreme Court agreed to hear the case, there was a lot of apprehension that it would lead to a decision greatly narrowing the scope of NEPA review. Based on the argument yesterday, I don't think they will go that far. They may simply say that an agency's decision on the scope of an EIS deserves a lot of deference. They may go a little bit further, but they clearly will announce a new rule about consideration of indirect impacts under NEPA, and that's likely to have some impacts on the way that climate change is considered under NEPA.
Very good, Mike. It's interesting how long NEPA has been out there generating litigation and all sorts of interest over the years. And I think it's going to continue to be with us for quite a while, which is a good thing. But this decision about CEQ not having the authority to issue rules, that sounds a bit far-fetched, but who am I? Pat or Mike, do you have any reactions to the NEPA part of this universe?
I agree with Michael Gerrard that I listened to the oral argument yesterday, 2 hours worth, that the court is definitely going to reverse the DC Circuit. And the question is how and how far they will go. I found it interesting that the so-called liberal wing of the court asked some of the most aggressive questions of the respondent, namely the plaintiff who brought this case challenging this rail line in the Uinta Basin of Utah, and made it pretty clear that they, including Justices Kagan, Jackson, and Sotomayor, were signaling to their conservative colleagues on the bench that if the court is willing to limit its decision to simply overruling the DC Circuit on the grounds that the DC Circuit went too far and did not give the Surface Transportation Board really much deference, if any, on its determination of what the scope of these indirect effects, which are frankly difficult to both quantify and even more difficult to deal with. So, you know, the idea that agencies don't have the authority to really meaningfully affect some of the impacts of a project for which they have a limited form of statutory authorization. In STB's case, they licensed the construction of this rail line, but their organic statute directs that they must approve lines unless they find it's contrary to public convenience and necessity. So what I'm saying is I can envision a modification perhaps of the way courts have been reviewing NEPA compliance and particularly environmental impact statements or environmental assessments, and probably signaling the lower courts to back off from fly specking, as Paul Clement, who argued on behalf of the proponents of the project, put it. And to, as Justice Kavanaugh said, if not give deference squared to the agency's interpretation of the scope of its analysis, at least give some pretty heavy deference to those kinds of determinations. That's what I would expect to see out of this. There's going to be many, many more things happening with NEPA law, though, than this one case. So just make a note of that as well.
So if I could answer, just chime in quickly on this, Dave. I agree absolutely with everything that Mike G and Pat are saying. The one thing that I would just note is, for those who didn't listen in or read the briefs, what the petitioner, Paul Clement, was arguing for, and taking the big swing, was this idea that indirect effects should not be analyzed whenever an impact is remote in distance and in time, and the agency lacks jurisdiction over the particular activity that would produce that indirect effect. And that rule, which is what he was arguing for, would significantly constrain NEPA analysis. It would basically get rid of indirect effects, because that's what indirect effects are. They're often remote in time and place, and they're often under some other agency's jurisdiction. The point that there did not seem to be a coalition that was fully buying into that, I think sounds right, although one does never know exactly where they're going to go. This issue does have particular salience for greenhouse gas emissions analysis under NEPA, because upstream and downstream greenhouse gas analysis almost always happens under the rubric of indirect effects or cumulative effects. And if an aggressive rule was adopted by the conservative majority, we might see far fewer EISs, including information about the downstream greenhouse gas emissions associated with various types of projects, even potentially including, in its most aggressive form, fossil fuel public lands leasing determinations. I don't think that that's where the court is going with this, but that would be the potential worst case scenario. To be clear, the CEQ, just in response to Cheryl Wasserman's comment here, CEQ did not, there was not a ruling that CEQ lacked authority. It was dicta in a concurring opinion that addressed issues that were not briefed. And I think that's important to recognize, that we are not dealing with something that some party argued for and a court adopted that idea. It was a Judge Walker going off on a tangent without any, without it adequately being presented to the court. There are a number of other comments in the chat that I'll try and respond to, those that I can respond to in the chat, Dave, just being mindful of time.
Very
I'll
good.
Let me
Oh,
just
go
say, I
ahead.
think there's going to be some argument about whether the DC circuit announcement on the CEQ regulation was dicta or a holding, and we'll see how that turns out.
Okay. Stay tuned. We'll see what happens. Okay, moving to a different category of cases, and actually this is the one that originally drew my interest, Montana constitutional case where some kids challenged, I don't know, I think it was a big mine development, and apparently there have been quite a few others. And Mike B., I think you're going to lead off on the state constitutional cases to set the stage, and then we'll ask Pat and Mike G. to chime in a little bit as well. Mike?
Well, I'll just note quickly on the state constitutional cases. There was a important decision last summer from a trial court in Montana. These all arise in these kind of youth plaintiff lawsuits, in many of which, or all of which in the United States involve the nonprofit organization Our Children's Trust as attorney for youth plaintiffs. There was a case in Montana that challenged a provision of a Montana statute that basically barred state agencies from considering climate impacts associated with fossil fuel projects in the state of Montana as unconstitutional. A trial court determined that, yes, in fact, the state would be violating that state's environmental provision in its state constitution if it refused and barred consideration of climate impacts from its environmental impact assessment processes. That case is currently under appeal, and we'll see how it is treated by the appellate courts in the state of Montana. Another significant development in the past year, a lawsuit was brought in the state of Hawaii by youth plaintiffs and reached a quick settlement endorsed by the governor, in which various kinds of climate commitments are now inscribed in a court enforceable, judicially enforceable consent order between the plaintiffs and the state concerning various aspects of energy policy. The one thing I'll just note on these state cases is there is, of course, a federal case as well, the Juliana case, which I'm sure everybody has heard of. And that case is, we just saw a cert petition filed yesterday, which I'm sure Mike and Pat will have plenty to say about if they choose to as well.
Mike, just a little follow-up question from me on this. Do you have any sense of, of our 50 states and the constitutions that they have, how many might be ripe for this kind of litigation? Is this quite common or is it unusual?
So the Montana and Hawaii are two of, I believe, and Mike and Pat, perhaps 6 or 7 states at this point. It may be as high as 8 that have environmental provisions in their constitutions, the right to a healthy environment in their constitutions, and those are the states in which one might see this kind of litigation.
Yeah, I'm sure Mike Gerrard can address the New York Green Amendment provision, but Pennsylvania has a very strong right to a healthy environment provision, which the Pennsylvania Supreme Court has actually given a lot of teeth and weight to in terms of citizen rights to enforce constitutional protections. Some of these states you would least expect to find these green amendments: Louisiana, Alaska, but also places where you would expect it, like Washington State. So yeah, I don't know the exact number of that. Maybe Mike G knows, but there are certainly a decent number. Now, how many of those states that have right to a healthy environment provisions would actually give effect to enforcement against the government on climate issues? That remains to be seen. But I think it's an area worth keeping an eye on. Mike G, do you want to comment on that?
Yeah, it depends partly on how you count. because I think there are about 6 amendments that are regarded as self-executing that don't require further state legislation to go forward. The newest was New York, which most of these were passed in the early 1970s during the era when most of our major environmental laws were passed. But in 2022, the voters of New York State, by a vote of 2-1, added to the Bill of Rights the following clause, quote, "Every person shall have a right to clean air, clean water, and a healthful environment," close quote. So nobody knows exactly what that means. There are several cases that are bubbling out. We need to wait. The Court of Appeals has not ruled, the top court in New York, so it may be very powerful or not. New York also has a strong climate law, the Climate Leadership and Community Protection Act, which has a section that requires all state agencies to consider climate change and reduction of greenhouse gases in everything they do. And that's also being litigated sort of at the same time. And there have been some recent decisions some of them give that clause force, some of them don't. So that the law in New York is really uncertain on this.
I would add one other thing on the Held versus Montana case, or a couple things. You know, the case did go to the Montana Supreme Court. I listened to the oral argument, and it seemed pretty clear to me that there was at least a majority of the Montana Supreme Court who would uphold Judge Seeley's decision, landmark really decision. Her decision, I don't know if Mike B mentioned this. If he did, I missed it. But I mean, this really is the first court in the United States to recognize a constitutional amendment, admittedly under a state constitution, but still, first time any court in the United States has ever recognized a constitutional right to a safe climate. So just for that reason alone, it's a landmark, right? In terms of the remedy it ordered, however, it's less than spectacular, right? So it didn't say, okay, Montana, stop licensing coal plants and oil and gas development and railroads that move all that stuff around. No, far from it. It basically said that the Montana state legislature had adopted a law, if you can believe this, it is Montana after all, that prohibited state agencies that are licensing infrastructure for oil and gas development from even considering climate change, from even considering the emissions that were going to result from their approval of these projects. And when the state appeared in the trial court and testified, they said, not only are we not doing it, we have no intention of ever doing it, no matter what you say, pretty much, to the court. And they made that same sort of argument as I listened to in the Montana Supreme Court, is that we are not going to consider climate change effects. So pretty dug in, I would say, in terms of the politics of Montana. So anyway, I think the Held case is a significant step forward in terms of establishing some strong constitutional basis for some of these claims. If it can be replicated in a few other states, if it can start sort of a trend, that's worth paying attention to for sure. On the Juliana case, very quickly, Juliana, never say never, never say die. They have, once again, our Children's Trust that represents the young plaintiffs in the Juliana case have petitioned the Supreme Court for review of the Ninth Circuit's latest decision, issuing a writ of mandamus this time around, saying this case must be dismissed with prejudice, never more. We're done with it. And interestingly enough, for those that are into legal tactics, I suppose, the petition for certiorari in the latest round in Juliana is saying to the Supreme Court, you have a case on your docket scheduled for argument in February that raises we think, the same or essentially the same issue on which our case was dismissed. It has to do with some, intricate questions of standing and redressability and the power of courts to order relief that actually ameliorates the injury to the plaintiffs that is being claimed. But the point is, they're trying to sort of be careful what you wish for, because asking this Supreme Court to review, standing to bring climate change cases is about as dangerous a proposition as I can imagine. I think we know what the answer would be if they took such a case like that. So it seems like the Juliana legal team is sort of saying, we want you to review this issue in our case, but we think you should wait until you've decided this other case. And if you decide in the other case that the standing issue in that case is identical to the standing issue on which we were dismissed in our case, then we think you should take up our case. I don't know if you were able to follow all that, but it gives you, I think, an insight into the intrigue, if you will, that's going on in some of these climate cases. I mean, it's pushing the law, it's pushing tort law, constitutional law, it's pushing administrative law, it's pushing every area of law you can think of. Climate change is actually forcing changes in the law, one way or the other. And that's what we see happening. I'll stop.
Yeah, not all of us were thrilled that the Juliana lawyers petitioned for cert, because as you implied, if they take it, this court may resolve finally the issue of whether there is a constitutional right to a clean environment, and clearly say no, and that'll be the end of it. But we'll see what happens.
Yeah.
That certainly is interesting. And going back to Montana, it'll be interesting to see if they run out of snow at Big Sky, whether or not they'll still say you can't consider climate change. So, stay tuned to that one as well. Fascinating at that state constitutional level. Shifting gears just a little bit in terms of, I guess what I'll call, rightly or wrongly, state-based climate liability, where people across state lines are bringing a variety of suits for damages that might be occurring at municipalities and otherwise. Pat, I think you're going to take the lead on this one, and then we'll ask the mics to chime in as well. Go ahead, Pat.
Yeah, so these are money cases, okay? So these are cases brought by states, cities, counties, tribes, the Commonwealth of Puerto Rico, and they are cases challenging primarily the big oil companies, what we call the carbon majors. These are the companies that have various kinds of analyses. Much of this work has been done by a man by the name of Richard Heady, who has calculated, what each individual oil company, and in some situations, petrostates, state-owned oil companies as well, Saudi Arabia and so forth. He's done the calculation to determine what portion of the emissions in the atmosphere are attributable to these individual major oil companies. So that's one of the predicates for these cases. They're seeking compensation for the relative contribution, based on this work that I've mentioned, of each of these individual oil companies, Exxon, Shell, Conoco, BP, the usual suspects. And the theories in these cases are quite extensive. They fall into different buckets. The one bucket is sort of traditional tort law, public nuisance, private nuisance, trespass, negligence, strict liability. Then there's a blend of tort law and consumer protection law, and that gets at failure to warn, defective product, false advertising, deception, campaigns of deception that have occurred over many decades, going all the way back to the 1960s. And there's a whole body of documents and literature. Think tobacco. This is very similar in that sense of efforts through investigative reporting and other means of uncovering what these oil companies knew, when they knew it, and what they did about it, what they said about it. So the core, I would say, of all of these cases seeking compensation in one form or another, I'll say a few more words about that, is deception. It really comes down to the tortious activity that's at the heart of these cases is not the emissions. It's not even the production necessarily of all of this fossil fuel. It's the marketing. It's the false, deliberately false, misleading attempts to portray, what the state of the science was and what these companies knew and whether they understood that their product was creating dangers that people needed to be aware of. All of that kind of intrigue, if you will, is at the heart of these cases. And so here's a quick rundown of the status. There have been a series of rounds of litigation in this area. The first round of litigation was the oil companies trying to remove all these cases to federal court. They're thinking, the federal courts are either going to be more sympathetic to their arguments for why they're not liable, or perhaps that it's a faster track to the Supreme Court, which is where they, of course, ultimately want to be. But let's say, and unanimously, all of the attempts to remove the cases to federal court have been defeated. So all of these cases are now pending across the country in state courts. So that was round one. That's been resolved. They're going to be adjudicated in state court unless they're thrown out. Okay. So that takes us to round two. So round two is motions to dismiss that the oil companies have been filing in virtually all of these cases. And the status of that is a little more complicated. By and large, the motions to dismiss have been denied in Hawaii in the Honolulu case, which Michael's involved with. Michael B is involved with. In Colorado, the Boulder County case was another extensive ruling denying motions to dismiss that case. Then you get a couple of decisions that are not entire victories. In fact, one entire loss from the governmental plaintiffs that are bringing these cases. One in Delaware, in which a judge said, "Well, a state judge, you can bring your claim that based on false advertising, deception, etc. But you can only seek damages for emissions within the state of Delaware." So that's one of these tricky questions of, can one state hold companies liable for activities that are occurring in other states, indeed in other places, right? So that's a tricky legal question in all of these cases that's going to take some time, as we say in Vermont, to sugar off. The other case, though, that's even more troubling is the City of Baltimore case in the Anne Arundel District Court, which dismissed the case entirely and said there's no basis. Basically agreed with the oil companies that the cases are preempted, either preempted by the Clean Air Act or preempted by federal common law. And I'm going to let you two Michaels address a couple of those issues in a little more detail. And she also ruled that there was no claim under the Maryland State Consumer Protection Law, which took everybody by surprise. So both of these the Delaware case and the Maryland Anne Arundel case are on appeal. And, I think it's too early to tell what's their fate. It seems to me that the Maryland case looks to me like it's pretty vulnerable to being overturned. I'm not so sure about the Delaware case, but we'll have to wait and see. So, the point is, these are mega buck cases. Okay, so the money that they're talking about is for adaptation. And if you can start to think about what that looks like with all of the storms and floods and fires, you see what's going on in Malibu right now, right? Sea level rise, coastal erosion, landslides, on and on and on. You're talking about billions and billions of dollars incurred in actual already incurred costs. But then when you try to project into the future what some of these costs are going to be and what states and cities are going to be able to do to accommodate and adapt and become more resilient to these kinds of impacts, these are mega buck cases. And of course, the oil companies are acknowledging that and saying, you keep this up and you're going to put us out of business. So, so the stakes in these cases are really high. The consumer cases are interesting because they're not only seeking penalties for violation of the consumer protection law, they're seeking disgorgement of profits. So for the period of time that you're found liable or guilty of deception, the states are going to be seeking compensation back to the consumers for the impacts of the deception. And I'll close with this. I mean, the science questions in these cases, the causality questions in these cases, are obviously huge and cutting edge, right? So attribution science, we don't have time to talk about a lot about that, but that's going to be at the heart of most of these cases. You've got to connect what's happening with global temperatures, global warming, to the damages that are occurring in individual localities along the coast, in floodplains and so forth. So that's one level of proof, connecting global climate change to localized impacts. Then the second level of causation you've got to establish is, how do you prove that the deception, first you got to prove the deception, then you have to prove, how did that deception lead to increased costs on the part of these local jurisdictions that are dealing with them? So how do you attribute to individual companies, once you've attributed the damage from climate change, how do you then attribute to individual companies their share of the liability? That's what gets into joint and several liability, think Superfund, right? And that's what gets into the restatement of torts, which says that if you are guilty of, or I should say, you can be liable for making a substantial contribution to the problem, notwithstanding that it's not the only or the sole or the major even contribution. If it's substantial enough, that's enough to trigger liability. So I'll stop there because I'm going on too long. But I think in addition to the fact that there's a fairness question here as to who should pay. That's the title of the article that my colleague and I, John Dermike, just wrote. Who should pay for these climate-induced damages and impacts? I mean, granted, the products that these oil companies were producing were things that people wanted. They were valuable commodities. So were a lot of other things that we can think of: asbestos, forever chemicals, glyphosate, leaded paint, and on and on and on. The point is, at some point, you have to ask, is it fair to expect the taxpayers in all of these different communities to bear 100% of the cost of these damages? Or is it fair to ask the companies who benefited somewhat dramatically financially from the sale and marketing of these products, is it fair to ask them to contribute at least their, quote, fair share to the costs incurred? So I'll stop there and let the two Michaels get in.
Michael G., you want to say a few words on that?
Yeah, I mean, there are a lot of interesting issues that arise. The case is based on a nuisance theory. The idea of damages is pretty clear. If the emissions from these oil companies contributed to climate change and to the need for seawalls and so forth, that's a fairly straightforward argument. The impact of the deception is not as clear. The fact of deception is very clear, though they have death to write on those issues. But to what extent did the deception affect consumer behavior? Did people drive more often or buy more gasoline or buy gasoline from different companies as a result of the deception? So the impact of the deception is going to be something that I'm sure is going to be fiercely litigated. Now, as Pat said, the damages are immense. If the oil companies were really held responsible for a significant portion of climate damages, it would be many trillions of dollars, and they would go into bankruptcy. They wouldn't go out of business. They would be bought out by somebody else. They'd be bought out by private equity or by state-owned oil companies or somebody else, and would continue in operation. Bankruptcy would presumably have wiped out the debt. So I'm not sure what I see as the end game in terms of money damages here, since the damages sought are, the principal assets of the oil companies is their oil reserves, and we want that oil to stay in the ground. The only way they're going to monetize that is if they drill it, and we don't want them to drill it. So I'm not sure how that plays out. But another interesting thing that's happening is the state of Vermont passed a climate superfund law, which wants to hold the oil companies, at least those that operated in Vermont, liable for a portion of the damages that Vermont has suffered as a result of climate change. And the New York State Legislature passed a very similar law, which has been on the desk of Governor Kathy Hochul. And I'm hearing that she may be about to sign it, possibly with some amendments. That clearly will be litigated. Both the Vermont and the New York laws will be litigated. But here, this is an attempt by the legislatures of those states to obtain through state legislation the same kind of relief that they've been trying for years to get in court. The precursor of all these cases goes back to 2004, when Connecticut and New York and some others sued American Electric Power and some utilities, seeking an injunction that they reduce their emissions from the coal-fired power plants. The Supreme Court in 2011 said the federal common law of nuisance was displaced because we have the Clean Air Act, and the Clean Air Act is the way that we regulate these kinds of emissions. Around the same time, another case called Village of Kivalina led the Ninth Circuit to say that although the American Electric Power case was about an injunction, and Kivalina was seeking money damages, it was an Alaskan village that needed to relocate at great expense. The same theory applied there. And that's a major reason why the oil companies all wanted to be in federal court, because they wanted that ruling to govern. And if the Supreme Court takes the Honolulu case that's now before them, I'm sure that theory is going to come up again, that these cases really are either displaced or preempted by the Clean Air Act. Just yesterday, the Solicitor General of the United States took the position that the Supreme Court should not take I'm sorry, that was in the Giuliani case that said that this should not take these cases, and so we'll see what happens with all of these.
Thank you, Mike G. Mike B., anything to add to that?
I would only note that while the vast majority of the cases that are currently pending in state court are filed under the deception-based theory that Pat was describing, there are some that are not. There is a case that was brought by Multnomah County around the heat dome in Oregon that does not really depend on deception as the basis for tort liability. I think it's questionable whether a case that was brought by a number of municipalities in Puerto Rico that also includes a separate federal RICO claim, depends on the deception-based theory, or whether the deception's about RICO, and then there's kind of more of a strict liability theory-based approach to that's premised on scope 3 or production-based emissions in some way or another. So there is some divergence in these cases. They're not all same counsel. There are different theories being promulgated, and we'll see how they all play out. They're very live, and there's developments every day in the state courts as to how they're going.
Well, as you all can see, we've covered the state and federal territory quite thoroughly here. And just to complete the picture, I want to turn our attention to what's going on internationally. And actually, a lot's going on all over the world, but perhaps particularly at the International Court of Justice in The Hague. And Pat, could you lead off this discussion about what's going on there?
Right. So they're in a process now before the ICJ on a referral from the Security Council or the General Assembly, whatever it's called, of the UN. And so this is seeking an advisory opinion. This would not be even what we would call a declaratory judgment necessarily within our jurisprudence. But nevertheless, it's a serious inquiry into whether what's happening, particularly, I mean, the moving forces in these cases are the countries of the world that are most at risk. This one is Vanuatu, which is one of these island nations that is basically going underwater. And there are hundreds, if not thousands, of these island nations and others, Bangladesh and others that are most at risk from the impacts of climate change and least responsible, obviously, for the emissions that are causing climate change. So it's an equity issue for sure. But, you know, in this case, the question is, does it violate international law? Not just treaty law or convention law, but customary law. And, you know, what would come out of this process is what international lawyers, of which I'm not one, would call soft law. It isn't going to have any enforceability aspect to it immediately anyway. But, you know, it would be establishing principles of international law. I mean, this is a judicial forum. I don't know how many judges there are. It seems to me like there's, maybe my colleagues would know, more than a dozen. I mean, I'm looking at the scene when I tune into the ICJ website, and it's just you know, it's just judges from one side of the room to the other, from countries all over the world. So when you think about the forum for this inquiry, it's impressive, right? I mean, you're talking about some of the brightest legal minds in the world, literally, you know, bringing a bright light of analysis to bear on do the countries of the world, led by us, of course, we have the most carbon in the atmosphere of anybody, and we have the most per capita contributions every year of anybody. Those that are responsible for the emissions that are causing this loss and damage and impacts around the world bear legal responsibility for it. So it's going to be incredibly important to see what this tribunal comes up with and how detailed it would be. My reading of a lot of different judicial decisions from other countries of the world, in Europe, in South America, in Central America, in Africa, is that the courts in those other jurisdictions that share some of the same core legal principles that we do, separation of powers between, you know, the legislative and the executive branches of government and the judicial branches of government, tort law, constitutional law, human rights law. You know, we share an awful lot, no matter where in the world you look at these cases. And yet, here's the thing that is striking to me. The courts in these other countries are more willing to undertake the somewhat treacherous responsibility for actually adjudicating responsibility, not just on the part of governments, but a very important case that came down from in the Netherlands on the heels of another important case called Urgenda, which held the Dutch government responsible for reducing immediately. This was the only decision so far where a court has actually ordered a national government to immediately reduce its emissions by 25%. And to its credit, the Netherlands government did. In fact, it went beyond the 25%. There was a downturn in the economy that helped with that. But the point is, there was an adjudication that the government was not doing enough, not honoring its commitments under international law, not honoring its commitments under constitutional and domestic law, and its duty of care to protect the citizens and so forth. You know, a judicial decision saying you must reduce now. So that was dramatic. On the heels of that, the Hague District Court in the Netherlands ruled that Shell, the Royal Dutch Shell, had a similar responsibility and duty of care based on human rights law and other sources of law to reduce by 45% its emissions, both its direct emissions called Scope 1, Scope 2 emissions of supply chain, and Scope 3 emissions of consumers, us, that pull up to the Shell gas station, right? So that decision was then overturned by the Court of Appeals in The Hague. But importantly, the Hague Court of Appeals said Shell does have a duty of care. We don't think the record in this case supports ordering Shell to reduce all of these Scope 1, 2, 3 emissions by 45% by 2030. We don't think the law supports that. We do suggest that Shell's continuing continuing expansion of its development, finding new sources of oil and gas, extracting more and more oil and gas and putting it into commerce and putting the emissions into the atmosphere. We do think that's a possible, issue for some kind of relief. So the court was giving sort of a broad hint, I would say, to the next phase of that litigation. The other one last case that I think bears mention is one called, I'm not going to get the name right. It's the Peruvian rancher farmer. He's also a guide. Liulula, I'm going to butcher that, I know, but it's versus RWE, which is a big German energy company. This is a case that's pending in Germany, in I think it's Essen. Probably have that wrong as well, but it's in a court in Germany. The interesting thing about this case, one last thing, is the court actually convened a site visit. They actually went to the village that's underneath this glacial lake that's threatened by the continuing melting of the glacier and the collapse of the dam that's holding the lake back, which would destroy its entire community. They actually went and did a very detailed site investigation with experts, spent several days on site, and they're now considering what to do about this. But if this court issues a verdict against RWE for the impacts of the potential loss of this lake and the damage it would do, that would again represent a landmark ruling, and one that it's very hard to imagine happening in the United States. But in other parts of the world, we're seeing courts stepping up and issuing pretty broad judgments, either against fossil fuel emissions or against government entities that haven't done enough. I'll stop there.
Very good, Pat. Mike G.
So if Mr. Lua wins his case against RWE, that'll be the first decision anywhere in the world holding fossil fuel companies financially liable for greenhouse gas emissions. Pat talked about the hearings now happening before the International Court of Justice. There have been proceedings in the last couple of years before 3 other international tribunals. The European Court of Human Rights issued an important decision in a case brought by a group of senior Swiss women, saying that the government of Switzerland was not doing enough to reduce that country's emissions. The government of Switzerland then basically gave the back of its hand to the court and said, we're doing enough. We don't have to do more. But the International Tribunal of the Law of the Sea, after an extensive hearing, ruled that the UN Convention on the Law of the Sea requires countries to reduce their greenhouse gas emissions because those emissions are having a negative effect on the oceans. And there's a case before the Inter-American Court of Human Rights raising human rights and theories, and they've held hearings. Mike B testified before, gave an argument before that court. I gave them a presentation as well. We're waiting for that decision. But a key point about all of these is their advisory opinions. The Swiss one tried to be directive, but not so much. Their advisory opinions, however, as Pat indicated, the domestic courts in a number of countries are taking these doctrines and issuing binding opinions. That's not happening in the US. The US is not a signatory to the human rights treaties that underlie many of these others. And as we've talked about, there's not a recognized constitutional right to a clean environment in US federal law, but there is in many other countries. And so these advisory opinions really can have an impact on the domestic courts in lots of other countries.
Mike B., anything to add to those comments?
I think these two have done a great job of covering the terrain.
No, absolutely. And Mike G., I was going to follow up and take a moderator's prerogative here to ask you. I'm just wondering if so many of these decisions in the international courts are really advisory. Obviously, a lot of time, effort, and money goes into bringing those cases, and it sounds like that they might have some degree of influence on home countries where people might be pursuing further litigation after that. Is that a fair assessment?
Yeah, yeah. And so Pat mentioned the Urgenda case, which is kind of the leading case globally using those theories and issuing a binding decision. But we're seeing a lot of litigation, and there have been successful cases on similar theories in France, in Germany, in Brazil, in Nepal, and several other countries around the world. We track all of these on our website. As I said, the US has 70% of all the climate litigation in the world, but some of the most interesting cases are emerging, and a lot of them are coming from the global South. We're seeing litigation coming from Africa, from Asia, a new decision from South Korea. So a great deal happening in the space, and it is largely because nowhere in the world are the governments doing enough to fight climate change. And so people use whatever tools they have, and litigation is an important tool. And the hope is that even if it doesn't lead to a binding, enforced decision, it adds public pressure, it adds to public consciousness. They're great organizing tools, and they can lead to legal doctrines that can have a real impact.
I wanted to go back to a comment you made earlier, Patrick, about raising the question, who's going to pay for all of the damages that are occurring out there? And it really struck me that to a certain extent, we're kind of back at the beginning of 1970 and the environmental laws, when there was a clear recognition that the costs of pollution were being totally externalized. And, the broader public, whether it's in health effects costs or, or environmental damage or things like that, was just being absorbed by the broader public, as opposed to the companies and the consumers of the products of theirs. So this is kind of that issue writ large with climate change, with absolute trillions and trillions of dollars of damages that are occurring. And, that's when the insurance companies start to come into all of this as well. And, it's showing up in insurance premiums and all sorts of other things. So thanks for that perspective.
Yeah, I mean, it's Coasean economics, really. I mean, it's Ronald Coase. His theory of an efficient market was you don't regulate, the sources of production for the impacts they may have. You use tort law to seek compensation when there is a market externality that causes harm to property or individuals. And in a way, that's what these state and local and other lawsuits are seeking to do. Whether they result in bankruptcy or not, it is a mechanism. It's not terribly efficient. Okay, I'll acknowledge that. It's not as efficient as a carbon tax. There may be problems with carbon taxes as well, right? But the point is, it may be the only sorts of remedy for some of these communities. So, I mean, we will see. It's a long way from being over, shall we say.
That's for sure. It ain't over until it's over, as we have learned over the years. I guess the famous Yogi Berra advised us that.
I mean, another issue that'll arise in this litigation, if it gets that far, is it's not the oil companies that are actually emitting most of this. The oil goes to motor vehicles that are manufactured by vehicle manufacturers, and we drive it. The coal companies don't burn the coal. It goes to the power companies that makes electricity. So where along the supply chain does liability attach? That's another issue we haven't gotten to yet, but I think will arise.
Yeah.
I alluded to the insurance issue, and Bruce Diamond has brought up the fact that we are going to have a session on insurance and climate change in the spring. So, keep tuned in to the webpage of the Alumni Association to find out more about that.
It's good to see Bruce Diamond's name on this. And Bruce, a shout out to you, my fellow regional counsel back in the day.
Yeah, Bruce is actually, he's got a major task as vice president of the organization in terms of keeping me honest. So
that's a big job.
It is a big job, but somebody's got to do it. And I might say that Bruce is doing an excellent job of that. I'm not facile enough to get through all of these questions, but I'm going to look to Steve Wheel, or do I have it right, Steve Weil or Wheel, who said, how can, Steve, go ahead. Your question about deference to the agency and perhaps a little inconsistency where some people are saying, well, they ought to defer to the agencies and others not. Go ahead, Steve.
Well, the question I asked was, how does this stuff on NEPA where they're saying, defer to the agency interpretation of the scope of their analyses and so on, go with the decision that you can't use Chevron, or the Chevron deference doesn't exist anymore, that was wrongly decided. How do they fit together, since the basis for the scope of the NEPA decision is in the law, I would think. I'm not a great NEPA law expert, but they don't seem to fit quite together.
I think Mike Berger took a shot at that.
Yeah, he did, and thank you.
Yeah, I mean, I think, Stephen, that the issue here is that the determination of the scope, the proper scope of an indirect effects or cumulative impacts analysis in any particular environmental impact review process is a technical determination that is subject to arbitrary and capricious review. It is not a agency-wide interpretation of a statute that would have formerly been subject to Chevron deference. And so I was also surprised in listening to the argument when they were really leaning into deference and deference squared, and should we be deferring to the agency? And it seemed like they just kind of want to swap in this idea of deference for the idea of deference that used to exist. But they're really talking about deferring to the technical expertise of the agency in applying law to facts in a particular context, rather than deferring to an agency's overall interpretation of the scope of its authority or something like that. If CEQ had a rule that was directly being challenged in this, that defined indirect effects in a particular way, or defined cumulative impacts in a particular way, we might be in the new Loper-Bright situation. But that was not the issue in the case that was being argued this week.
Yeah. I would just note, as an aside for everybody, I was involved in two of the most expensive EISs ever written for Yucca Mountain, which ended up almost $120 million cost to DOE, and the Hanford Tank Closure and Waste Management EIS, which was a bit more expensive. I don't think it hit 140, but it was enough.
And of course, it came up frequently in yesterday's argument that last year at the Fiscal Responsibility Act, the law that extended the debt ceiling, that Congress said that EISs should be limited to 150 pages. Now, there was a big exception there. It doesn't count the footnotes. I'm sorry, it doesn't count the appendices.
Yeah.
But the court yesterday was pressing on the issue. If you want to address all of these indirect impacts that the plaintiffs want to address, how are you going to keep it all within 150 pages? And Congress has clearly expressed the view that EISs should be short and sweet.
Very good. Well, we are approaching the bewitching hour, and we've wandered very dangerously into happy hour already. So in the true spirit of having three outstanding lawyers, I'm going to give each one of you a little chance for a closing, if not argument, at least comment or remark. Michael G., why don't you kick it off, and then Michael B. and Pat, I'm going to give you the last word, or second to last word, because I'm going to follow you. So Mike G.
So we are about to enter a new era of litigation, challenging everything Trump is doing. And we're in a situation where whatever party is in power, the other side sues. So our litigation database is going to continue to grow considerably. We're going to see a large volume of litigation challenging the things that Trump did. The last round, NYU did a study saying that the Trump administration won only 31% of the legal challenges to its major rulemakings, mostly because they were sloppy. We'll see if they're more careful this time, but being careful takes a lot of time and it takes a lot of staff. and it's inconsistent with the slash and burn attitude that Musk and Ramaswamy are taking. So we don't know how that'll turn out, but it'll a lot of work for lawyers on both sides.
Very good. Mike B.
Litigation is a time intensive, high expense, high uncertainty way of going about achieving the kind of change that we need to achieve in government and private sector activities to address the climate crisis. I'm often asked, is litigation going to kind of solve this? And my answer is always no. Litigation, there's no case that provides a silver bullet either to enforcing the polluter pays principle in the climate context, or forcing governments to adopt adequate ambition and implementation of that ambition to address the mitigation and adaptation needs of climate change. All that being said, it's a very high level of activity we're seeing in the courts, and it is definitely going to intensify in the months ahead.
Thanks, Mike. Pat.
All right. So I would agree with my distinguished colleagues and add that we all have an opportunity and a responsibility, I think, to do in our own world, in our own communities, bottom up, as much as we can to reach out to people, educate people that are willing to be educated, listen to people who have other points of view about the danger that climate change presents and the opportunities there are for transitioning our energy and transportation and other systems to systems that work for people, meeting people where they are. I mean, I just think that whether we're lawyers or scientists or engineers or whoever we are, that understand what's at stake here for us and for our kids and grandkids, right, going forward. This is the moment. I mean, we've all got to do what we can, to make a difference. And we can't let, the fact that Trump got elected stop us. We can resist. Yes, that's a big part of it, as Michael G. has said, but also working to find good candidates to run in the midterm election, for example, or supporting the ones that you already know about, not only with money, but with phone banks and door knocking. I mean, that's where we are right now, is we don't have a political consensus to do what's necessary. We've got to build that. We've got to build it from the bottom up. Grassroots action. That's kind of, I think, where we are. Can't look to the federal government. Those of us who started this game back in the 70s thought it all came from Washington, D.C., right? It all came from the federal government on down. It's reversed in a way. So now it's up to us in our own communities and families and in our extended sort of professional networks to do what we can. So I urge everybody to do it.
Well, I feel compelled in the light of Pat's comments to reinforce that we are a nonpartisan organization and we are not encouraging anyone to vote in one direction or another. But Pat always speaks his mind, and he is speaking for himself.
Well, voter education.
Yeah, voter education. Okay, that's very good. And in keeping with what other items Patrick mentioned, get your solar panels, get your electric car, get your heat pumps, and drive down your own costs and reduce greenhouse gas emissions. I really want to just thank all three of you for absolutely outstanding presentations. The depth of your knowledge is absolutely phenomenal. This clearly is an area of the climate change set of issues that is playing out and probably will continue to play out in an even bigger way in the future. And this puts all of us in a better position to understand this and, to think globally and act locally, as has been said many times over the years. So thank you to the panelists. Thanks to everyone who was on. We had a lot of people stay well through happy hour to do it. I'm going to move on to that in just a few minutes myself. But again, thank you. We will have a little opportunity for, we call it breakout sessions, I don't know, chat rooms, whatever. So those of you who need to move on, please do, and thanks for being on. Those who would like to stay and chat a little bit, we will do that as well. Mike and Pat, thanks again.
Thanks
Thank
very
you,
much.
David.
Thank you.